Good day, ladies and gentlemen. Joy Stephen from the Polinsis Studios, and here is a case law for the Student Herald, Navaratnam versus Canada. Case laws are not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair, or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog reportersreport.com as a PDF document. This case law is an immigration case law, and it deals with topics like refugee status, procedure. Refugee claimants were citizens of Sri Lanka who alleged fear of persecution by Sri Lankan authorities and paramilitary groups. Claim was heard in March 2013 by Refugee Protection Division, RPD, member who became ill prior to rendering decision. Claimants were given option of de novo hearing or of having another member decide their claim based on evidence, submissions previously made, and the transcripts of proceeding. Claimants chose the second option, but contended that counsel had requested that he be provided with a hearing transcript in advance of any determination by new member. Transcript was not disclosed, and significant portion of reasons were devoted to questions of credibility. Member concluded that principal applicant's evidence was not credible and was therefore insufficient to support claim. Member concluded that principal claimant was not a convention refugee pursuant to S96 or person in need of protection under S97 of Immigration and Refugee Protection Act of Canada. Claimant applied for judicial review, contending that member breached requirements of procedural fairness and natural justice by failing to provide them with copy of transcript prior to rendering in chambers decision as they had requested. Claimants contended as a result they were denied fair hearing and they had no opportunity to speak to members' credibility concerns. Application was dismissed. Failure to provide transcript prior to a new member issuing his decision did not result in a breach of procedural fairness. Parties identified no RPD rule or other process that applied in event that member who had conduct of hearing was unable to render decision. It was therefore open to RPD to offer claimants choice that it did either hearing de novo or in chambers decision by another member based on transcription of evidence led and presented at hearing. There was no evidence as to whether co-ordinating member agreed or did not agree to claimant's counsel's request for transcript. Claimants had benefit of full hearing before member, at which they were represented by counsel who made submissions on their behalf orally and in writing. To extend that credibility was raised as concern at that time, it could have been addressed. Record does not indicate that request to make post-hearing submissions of credibility or any other issues was made by counsel who attended hearing, and there was no evidence that RPD agreed or would have agreed to new submissions based on transcript. Indeed, in normal course, claimant would not be entitled to be provided with review and respond to hearing transcript prior to decision being rendered. Interesting case again. Navaratnam versus Canada, dated May 21st of 2015 from the Federal Court.